So welcome back, sir. In the last class, we have completed the fourth chapter, that is Memorandum of Association, Articles of Association, and also we have completed the concept of Section 8 company. है ना? So I hope you people are revising every day. So till now, we have completed 4 chapters. Let us enter into next chapter, that is foreign companies. As per material, so he is covering 228, 234, 276, 279 and 380, 381, 382, 383. So till here he is discussing about the concept of foreign company in CMA final syllabus. So let us start with the chapter. So what is the concept of foreign company? So first of all, what is a foreign company, sir? Let us try to understand. Sir, foreign company may be a company or it may be a body corporate. Body corporate means any artificial person which is registered outside India. So foreign company may be a company or a body corporate which is incorporated outside India, which has the place of business in India. That means company registered outside India, but they're having the business in India. For example, assume this is India. So there is a company which is registered, assume this is some foreign company, example USA. There is a company called Microsoft Computers which is registered outside India, but they are having a branch office in the Madhapur, for example. है ना बेटा, clear ना? So here we are having the in Madhapur, they are doing the business, no? This whatever in Microsoft Computers, it is a foreign company which is registered outside India, which has the place of business inside India, which has the place of business in India, that is said to be a foreign company. Which company, sir? Foreign company. So what is a foreign company? It is a company or body corporate incorporated outside India which has a place of business in India. It may do the business in India either by itself or through the agent. So they may do the business in India by opening their branch office in India, or they can give it to they can also have the agency also. For example, Harley Davidson, so they're having the agency in India. For example, Microsoft Computers, they're doing the business on their own in India, so they may do the business in India either itself or through agent. They may do the business in India either physically like Harley Davidson, they may do the business in India electronically like Amazon India. So Amazon is there, no? They're doing the business in India electronically, so conduct the business activity in India in any other form. So what is a foreign company? Once again, it is a company or body corporate which is incorporated outside India, but which has a place of business in India. Company or body corporate incorporated outside India, place of business in India. They may do the business in India through itself or through the agent. They may do the business in India either physically or the electronically. So this question is important. He is asking the MCQs. This question he is asking in CA enter also, CMA enter also, and in CA final also. In CMA final he is given the much depth about the concept of foreign company. Next, section 228. What is 228? Inspection, inquiry and investigation. So when inspection will be conducted, when inquiry will be conducted, when investigation is conducted, that will be covered in chapter 14 of the company set. We will be seeing in the subsequent classes in the CMA final. For example, if company does something wrong, some rumors are going on the company, then Ministry of Corporate Affairs may go for the inspection. They may do the inquiry, they may do the investigation also. For example, Adani, so recently they did some inspection. For example, Vijay Mallya, for example, for example, that Satyam Computers, so in case of Satyam Computers, in case of the Vijay Mallya Kingfisher beverages, so there was the inspection was conducted by central government, inquiry was conducted, investigation is conducted. If you are observing Satyam Computers and whatever that Kingfisher beverages, so these are the Indian companies registered under the Indian Companies Act. So they're doing something wrong, so government is having the proof also, so they'll conduct the inspection or inquiry and investigation under chapter 14 of the Companies Act. In the same way, there is a company like Harley Davidson, there is a company like Samsung, there is a company like Microsoft Computers. So if any of these companies which is registered outside India doing the business in India, if they are doing any wrong thing, central government is having any evidence, so even for that foreign company also, government of India will conduct the inspection, inquiry, investigation, same like Indian company under chapter 14 of the Companies Act. The provisions as to inspection, inquiry, investigation under Chapter 14 of the Act shall mutatis mutandis equally applicable to foreign company also. Mutatis mutandis ante as it is or similar to. Mutatis mutandis means similar to. If Indian company doing something wrong, government of India will conduct the investigation or inspection under Chapter 14. In the same way, even foreign company also doing the same kind of the something wrong. So government of India will do the investigation under Chapter 14. Clear na? Because they are doing the business in India. Next, merging into company registered under the this act vice versa. So what does it mean? There is a foreign company is there. The foreign company want to merge with the Indian company. For example, Harley Davidson, foreign company. They want to merge with Tata Motors. So how it should be merged is defined, is explained by this topic, that is 1.1.3.2 in your initial material, final material. You can also compare with the initial material. So he's explaining all these things under single chapter only. He's giving the numbering like this. So what does it mean? So when foreign company is there, like Microsoft computers, and they want to come merge with Tata Consultancy Service. Otherwise, Harley Davidson is with Tata Motors. So what is the procedure? A foreign company, sir, he may ask in the MCQ also, can the foreign company merge with Indian company? Answer is yes. So a foreign company may merge with prior approval of the Reserve Bank of India, merge into a company registered under this act. In the same way, Indian company also merge with a foreign company also. But we have to get the consent of the Reserve Bank of India, because here foreign exchange is involved. Clear na? And as per the terms and conditions of the scheme of the merger, the payment of consideration for the shareholders may be paid in cash, may be paid in depository receipts. They may be paid in partly in cash, partly in the depository receipts. That is GDR and ADR. So as per the scheme of amalgamation, here two things are there. A foreign company can convert into merge with Indian company with approval of the Reserve Bank of India. He may ask in the MCQs, don't forget. So foreign company can convert into can merge with Indian company with the consent of the Reserve Bank of India, and as per the scheme of merger, and to the shareholders of the company, that merged company may pay cash or GDRs or ADRs and cash, and also deposit receipts also. Clear na beta? Simple. Here what he can ask max. So whose approval is required if the foreign company want to merge with the Indian company? Vice versa. MCQ में आने के chance बेटा. A ROC, B MCA, C RBA, D none of the above. Generally we keep the ROC or the MCA, but answer is RBI. है ना बेटा? So if we remember, if you write 1-2 times, easily you can score 2 marks. है ना बेटा? And this concept is recently included in the new syllabus of CA Inter also बेटा. Foreign companies. Next, winding up as an unregistered company. What does it mean? So there is a company like Microsoft Computers. It is a foreign company which means registered outside India, doing the business in India. So they came to Madhapur, then doing the business in Madhapur. They are closing the business in India and they want to go to America itself, for example. Clear na beta? So that foreign company should be wind up as an unregistered company in India. Hai na? So where a body corporate incorporated outside India, which has been carrying on business in India, registered outside India, doing the business in India, ceases, that means stops to carry business in India, it may be wound up as an unregistered company. So what is this wound up as an unregistered company? In our company sector, procedure is there how to wind up the unregistered company. Clear na? So as per that procedure only, foreign companies will be closed in India. So what is the procedure for closing of the unregistered company in India is not there in our syllabus. It is there in the CA final, but not in the CMA final. Whether or not it is dissolved under the laws of the country under which it is incorporated. What does it mean? Microsoft Computers is registered in the America. In America it may be dissolved or not, but from India they are closing all the business. So for the Indian business it is deemed to be wound up as an unregistered company in India. Clear na beta? So once again, a foreign company closing the business in India, it should be wound up as an unregistered company in India, whether it is closed in America or not, the foreign country or not. Clear na? Next, application. This is very important, sir. he may ask in the exam, application of the act to foreign companies. Beta, there is a company like Harley Davidson, Microsoft Computers, Samsung, Suzuki, and beta. All these are foreign companies, not the Indian companies. Suzuki, Samsung, Microsoft, and beta. Whether we will apply Indian companies act to these companies, generally answer is no, because they're not registered in India. However, we will apply the Indian Companies Act to this foreign company also if the following conditions are satisfied. Let us say what are that? है ना बेटा? For example, there is a company called Harley Davidson. It has 100 shares. Out of 100, more than 50% of the shares held by Indian citizens are Indian companies. One or more companies or body corporates incorporated in India. Indian citizens or Indian companies are Indian citizens and Indian companies jointly. Then we will apply the whole the provisions of the Companies Act to that company also. Even this Harley Davidson is registered in the America, water foreign country, but whose money is there in that foreign company? Indians money. How much money? More than 50%. So for this Harley Davidson also we will apply all the provisions of the Companies Act. If Harley Davidson doing the business in America itself, we will not touch, we will not apply our Companies Act to that company. है ना? Harley Davidson registered outside India, Microsoft registered outside India, Samsung registered outside India, they're doing the business in India, and in that company, more than 50% of the share capital is held by the Indian citizens or Indian companies, Indian citizens plus Indian companies, then we will apply the provisions of the Indian Companies Act to that foreign company also. If 50% or more of the paid up share capital of the foreign company is held by Indian citizens, one or more of the Indian citizens, one or more of the companies or body corporates incorporated in India, that means Indian companies, one or more of the Indian citizens plus body corporate incorporated in India, then foreign company shall, in respect of all its Indian business, comply with chapter 22 of the Companies Act and other provisions of the act as may prescribed by the central government as if it were a company registered in India. So if that foreign even it is a foreign company, we will consider it is a Indian company. We will apply the provisions as specified by the central government to that foreign company also, because more than 51% of the capital is held by the Indians. Let us revise the whole page one more time. So please do write running notes, sir. I hope you are revising chapter 1, chapter 2, chapter 3, chapter 4 already. This is chapter number 5. So first, what is foreign company? It is maybe company. It may be a company or body corporate registered outside India, place of business in India through itself or through agent. They may do business physically or the electronically. If the foreign company closes business in India, it should be registered as an unregistered company in India. This can also, you can ask in the MCQ, how a foreign company can be wound up in India if it is serious to carry on business in India. A, B, C, D. One of the option will be as an unregistered company in India. So investigation provisions will also applicable to foreign company also, and foreign company can be merged with Indian company, vice versa, with approval of the Reserve Bank of India as per the scheme of merger. We can pay in cash or DRs or DR plus cash also. If more than 50% of the foreign companies held by the Indian citizens or Indian companies, Indian citizens and Indian companies, we will apply the provisions of the Companies Act to that foreign company also. Clear na beta? Next, 380 documents to be delivered to ROC by foreign companies. For example, beta, one foreign company want to do business in the India. For example, as we discussed, Microsoft Computers want to start their office in the Hyderabad, Madhapur. So they have registered with the ROC or not, sir? Answer is yes. So if they want to register with the ROC, which documents we have to file it with the ROC? Let us see. Legal requirements when the place of business is established. Once they are starting the business in India, no, every foreign company shall deliver to ROC for registration. Every foreign company shall deliver to ROC for registration a certified copy of the charter, MOA and AOA. If such instrument is not in English, translate them into English. What does it mean? If foreign company want to do the business in India, we have to give the copy of MOA and AOA with ROC. If it is not in India, convert them into, if it is not in English, convert them into English and give it to ROC. If it is the company registered in the Uganda, so they may prepare MOA, AOA in the Uganda language, convert into English language and give it to ROC. And full address of the registrar office or principal office of the company. That means register address of the foreign. है ना बेटा, Microsoft computers having the registrar office in the, for example, for example, USA. So we have to give the USA address, USA corporate address to ROC. So we have to original MOA of the company, translate them into English, and we have to give the USA address to ROC, and full address of principal place of business in India, that is the Madhapur address, that is the Indian address. So we have to give the foreign address to ROC, original MOA, translate them into English, and Indian address, and principles of opening and closing of the place of business. When they're opening the business in India, when they're closing the business in India, we have to inform to ROC, and list of the directors and CS contained in the such particulars. So for Indian business, who are the directors and who is the CS? So directors, the details of the directors and CS we have to give to ROC. Names and addresses of the persons resident in India authorized to accept on behalf of the company. If the ROC want to send the any notice, if government want to send the any notice to such foreign company, so company outside India, no beta. So who is authorized to receive the notice in India? So that address, their name we have to give it to ROC. So address and name of the persons who is authorized to receive in India, and declaration that important declaration. Sir, this thing he can ask us 1 marks question also, beta. Clear na? New concept which was not in the old syllabus also. So he may ask in the exam a declaration that, sir, in the place of foreign company in the old syllabus we used to have the producer companies, that was altogether removed. Producer companies and Nidhi companies used to be there in the old syllabus in the CMA final. That is also very important. So there are so many questions who are based on the producer company in the old syllabus, but the total syllabus itself is removed in the new syllabus. So in the place of producer company, he is keeping the foreign companies, which is very, very important from exam point of view. Listen carefully, okay na? So a declaration that none of the directors of the company authorized representatives in India has been convicted and barred for formation and management of company in India and abroad. What does it mean? So we have to inform to ROC. So these are the directors, and these are the directors of the company in India. These people are not debarred from doing the business in India or in the foreign. So our Indian representatives are the good people but not the bad people. A declaration that none of the directors of the company or authorized representatives in India has ever been convicted or debarred from formation of the company or management of the company in India or the foreign. So our representatives in India are the good people but not the bad people. We have to give a declaration. So such other information we have to give to ROC. Once again, first, if the foreign company want to start the business in India, we have to give the original MOA and foreign address, Indian address, and date of opening and closing the business in India, directors and CS in India, and who is authorized to receive the notice in India on behalf of the such foreign company. Nothing but both of these people only, see director's name only, and declaration that they are the good people but not the bad people. They are not debarred, they are not convicted under the act, this Companies Act or Foreign Companies Act, for doing the business or forming the company in India or the foreign. So all these things we have to give to ROC. So when we have to give it with ROC, the documents will be delivered with ROC for registration within 30 days of establishment of place of business in India. So all these documents we have to give to ROC. No. So when we have to give these documents with ROC, all these documents should be filed with ROC within 30 days of opening of the business in India. Manner of filing. So how we have to file all these documents with ROC? Within how many days? 30 days. In which form? In FC1. FC means foreign company. In form number IN7. So the document is required to be filed under section 3.8. It should be filed in form number FC1. And an attested copy of the approval of RBI and FEMA should also be filed with along with all these documents. So along with MOA, foreign address, Indian address, date of opening and closing of the business, directors, CS declaration, and also approval of RBI and approval of FEMA. So whenever FEMA comes, RBI comes. Whenever RBI comes, FEMA also comes. There like wife and husband, sir. Whenever foreign exchange comes, no, these two people will come. So all these things we have to file it with ROC within 30 days of opening the business in India in form number INC, in form number FC1. So after closing of the business also we have to inform to ROC or not, sir. So we are starting the business, we inform to ROC. Notice of cessation of place. Cessation means closing of the business. It shall forthwith give the notice to ROC. Once notice is given to ROC, obligation of the company to deliver any document to ROC shall also cease, If it has no longer place of business, once you're closing the place of business in India, you have to inform to ROC. I hope this section 380 is clear. So if you want to start the business in India, you have to reissue with the ROC. For that, original MOA, if it is not in English, translate them into English. Foreign address, Indian address, date of opening, date of closing, and directors and CS names in India, and who is authorized to receive the notices on behalf of the foreign company in India, and declaration that they are the good people but not the bad people. They are not convicted. They are not debarred from formation and management of company in India and foreign also. And all these documents we have to give to ROS within 30 days in form number FC1. This can also you can ask in MCQ. Along with all these documents, we have to give the approval of RBI and FEMA also. Once we are closing the business in India, also we have to inform to ROS. Once we are informing to ROC that we are closing the business in India, so no further document is required to given to ROC, because we are no more doing the business in India. Next, section 381, accounts of the foreign company. So what is foreign company? Registered outside India, doing the business in India. If they're not doing the business in India, all these things will not be attracted, sir. These things will be attracted if you are doing the business in India. So how they have to prepare the P&L account, how they have to prepare the balance sheet being a foreign company, as similar as to Schedule 3 of the Companies Act. Simply. Clear na beta? So preparation and filing of balance sheet and P&L. Every foreign company shall prepare and file with ROC balance sheet and P&L account in such a form as may be prescribed. And containing such particulars as may be prescribed, including annexes as may be prescribed. Nothing is there in these 3 points, frankly speaking. So foreign company has to file the copy of the P&L balance sheet with ROC. That's it. If document is not in English, translate them into English. Central government can also exempt. The summary of the whole these 10-12 lines is, every foreign company has to file the copy of P&L balance sheet with ROC. If it is not in English, translate them into English. That's it. So when we have to give every calendar year, not financial year anta. So list of place of business. Every foreign company shall prepare list of all the places of business in India. The list shall be prepared in FC3. It shall also be prepared as at the end of the balance sheet date, and it shall be filed with ROC along with the P&L account and balance sheet. So we have to give the P&L, balance sheet, and list of the places of business in India. We have to give it to ROC. Clear na? So how we have to prepare is specified by Rule 4 and Rule 5. So how we have to prepare this P&L and balance sheet in Schedule 3 are as near as may be possible, and similar to Schedule 3. Prepare as per Schedule 3 if not possible, something nearer to Schedule 3, and all the documents have to be required to be annexed to finance statements, that is CFS and etc. as prepared as per the chapter 9 of the Companies Act, that is a pro forma of the P&L and balance sheet and CFS etc. Company shall also, along with finance statements, prepare a statement containing the related party transactions, repatriation of profits, and transfer of the funds. So along with the P&L balance sheet, foreign company should also prepare the related party transactions. That means if the company is entering into a transaction with the directors, promoters, holding company, subsidiary company, that thing also we have to give to ROC. And repatriation of profits. Repatriation means transfer only. So foreign company doing the business in India, they're making some profits. So how much of the profit they're taking back to the foreign country. That thing also we have to inform. And transfer of any funds, both are same more or less. This is the funds, this is the profits. So repatriation of profits and funds also we have to inform to ROC. So as per Rule 4 and 5, it should be filed with ROC within 6 months from end of the financial year. As per section, he said it is calendar year, but as per the rules he is specifying it is specifically 6 months from end of the financial year. Rules will override the act, remember. So rules will more powerful than the act. So we have to file all these things with ROC within 6 months from end of the financial MCQ. ROC may grant the extension of 3 months also. So since companies filing the P&L balance sheet with ROC, so it will get the authenticity, validity if it is audited. That's why foreign company P&L account balance sheet also audited by the CA into practice in India as per Chapter 10 of the Companies Act. That is the Audit and Auditors chapter of our Companies Act. So summary of the whole thing, let me write here. Every foreign company has to prepare P&L, balance sheet plus other annexers. Similar to Schedule 3 in English, and also place of businesses in India, place of business in India, along with the repatriation of profits, and also related party transactions, P&L, balance sheet similar to schedule 3, and also all the place of business in India, repatriation of profits and funds, related party transactions. All these things should be filed with the ROC within 6 months from end of the financial year. ROC may also grant the 3 months extension. That's it. That is summary of the whole page. That is section 381. Clear along with the rules. So foreign company has to prepare balance sheet and P&L and any other annexures also, and we have to prepare as similar to as schedule 3 and translate them into English if it is not in English, and also prepare the places of business in India and repatriation of profits and funds and related party transactions. All these things should be filed with the ROC within 6 months from end of the financial year. ROC may grant extension. All these things should be filed with the ROC in form number FC3. This summary of the whole section 381. Clear na beta? Next section 382 and 383. This is the last topic in this chapter as per your material. So something more is there, but everything is not covered in CMA final material. This is what is covered. First, display of name of foreign company. Beta, he is explaining about the display of the name of the foreign company in 2 places. One is outside the office and also on the bills, letters and vouchers. So company has to specify the foreign company address, foreign company name on the outside the office and also papers, vouchers, documents also. Let us see. First, duty to exhibit and show cause and showing. Duty to exhibit its name, etc. Duty, name and etc. and something other things also there, name along with the name. Exhibit the name outside the place of business. Due to exhibit its name etc. on the bills, letters. So we have to notify all these the information on the outside the office and also the letters and bills. First, outside the office, what we have to display. Foreign company shall exhibit outside the every office or place where it carries on the business in India, name of the foreign company like Microsoft Computers, country of incorporation like United States of America, and the fact that liability of the members is limited. That is the liability clause. The members liability is limited. LTD will be there, no beta. SG limited, SG private limited. So the fact that members liability is limited. Above particular should be conspicuously and easily visible. Conspicuously means easily visible. It should be exhibited in easily visible place, not in the inside somewhere. So name of the company, country of incorporation, the statement that the members liability is limited. So we have display in a conspicuous place. That means easily visible place in English language and also local language like Kannada, Telugu, Marathi, Gujarati. So we have to specify these 3 things in local language and also English language outside the office. And inside the office, on the letters, bills, vouchers will be there. No, what we have to display. Foreign company should exhibit a display in legible English letters. Name of the foreign company, Microsoft Computers, country of incorporation, United States of America. The fact that members liability is limited. Where we have to display all these things: business letters, bill heads, letters, papers, all the notices and all other official communications of this foreign company. Simply, we have to specify the name of the foreign company, country of incorporation, statement that the members liability is limited on the outside the office, even on the bills, vouchers, letters, all official communications. That's it. 382. So last section as per our material, section 383. The service of documents on foreign company. For example, beta, ROC want to send some service means sending beta. ROC want to send some notice to this foreign company. So how we have to send? A document required to be served and transferring, sending, served on the foreign company shall be deemed to be served sufficiently if it is addressed to any person whose name and address has been registered, has been delivered to ROC. That is a person resident in India who is authorized to accept on behalf of notices to be served are left at the register office in India through speed post or electronic mode. Same foreign company, ROs want to send the notice to foreign company, so they want to send the notice to, they can send the notice to person authorized to receive, simply person authorized to receive notices on behalf of that foreign company, or we can send it to register office in India, register office in India. How we can send it? This is second B. How we can send it through post or through the email, and but electronically means email. So once the notice sent to person authorized to receive the notice in India, or we if you send it to registered address in India, that is deemed to be served or sent to that foreign company, such any notice or any information, we can send this information through post or the electronical. Clear na beta? So with this we have completed the small chapter of foreign company. It is a new which was not there in the old syllabus of CMA final, old syllabus of CA intern or CMA intern. So altogether new concept for the CMA final paper. So do 3-4 revisions. It will be easy, sir. Paper is not tough, paper is lengthy. I am telling from the, I told in the first class itself, hai na beta? So remaining part we'll see in the next class. Have a great time, enjoy the day, prepare well. SG signing off, take care. Do revision, make running notes. Clear na?